the part heard appeal in the matter of Quaye and the Secretary of State for Justice.
Yes, Mr. Fitzgerald.
My lady, I was somewhat saved by the bell yesterday, so what I've done is to overnight to try to address the point that my Lord Justice Lewis put about the significance of the change in 82A. Obviously, we hadn't dealt with it because it was not a point pursued below or in the appeal by the appellant, but it's clearly something that we need to address now. And so just very briefly, the way we put it is set out in our supplementary note. Does the court have that?
Yes, so I've had an opportunity to have a quick look at it, but not all members of the court have
I
yet.
got it now.
So
It's probably on the desk. I hadn't seen it before.
Well, if it summarised the point I'd made orally, but rather briefly yesterday. But the introduction we respectfully submit of the section 82A in the powers of the Criminal Courts Act did not alter the nature of the sentence. You have section 82A appended to the note as the first of the statutory provisions, and you can see that this section applies if a court passes a life sentence, and then it says in this section, court includes a court-martial. Life sentence has the same meaning as in chapter 2 of part 2 of the Crime Sentences Act. So, and then if we look back to section 34, which is at page...
Whatever you're referring to, I'm afraid I see, no, this
Does my lord have it at page 6? Yes, my lord, it's page... So at page 6 you've got 82A, and the point that my lord put to my learned friend and myself was, well, in subsection 7 of 82A, life sentence has the same meaning as in chapter 2 of part 2 of the Crime Sentences Act. So if we then go back, and this is at page 14, to the meaning in section 34, one sees that section 34, subsection 2, page 14, in this section, life sentence means any of the following imposed for an offence. A sentence of imprisonment for life, B, a sentence of detention during Her Majesty's pleasure. So the provision and the purpose of that was to ensure that HMP detainees could have the right to the review set out in section 28 of the 1997 Act, which one can go back to pages 10 and 11, that when they had reached the tariff period, their case would be referred to the parole board under section 28, subsection 5. So all that statement was a device, originally in the 1997 Act, for all indeterminate sentences that merited it, in those days the discretionary life from the HMP detainee, to be referred to the parole board.
when you say statement, what do you mean all that statement was?
Well, the statement that it has the same meaning as
Provision, you mean?
So if you look at section, I'm so sorry, my lady's quite right. So all that section 34
Section 34 too.
is intended to achieve is at 34 2AB, that life sentence for the purposes of these provisions will include a sentence of detention during Her Majesty's pleasure. It obviously doesn't turn the sentence of detention during Her Majesty's pleasure into a life sentence, and moreover it predates certainly the Smith case. I think Venables was decided in January of 1997, but Smith
case, the sentence predated the act, and that's the point that Lord Bingham was making.
Yes, but the words, to the extent that one has the language of a life sentence, includes HMP detention, that had long predated. But my lord, I appreciate what I've got to address is my lord's point. Well, Lord Bingham expressly said, well, I'm not going to deal with that position. But if one looks at the context in which he said it, which is at paragraph 15, so in Smith at page 321, what he says there is and this is at 321 paragraph F to G. He points out that the legislative responses have been piecemeal, but whether an anomalous distinction exists between pre and post 19 November 2008 HMP depends on the interpretation of Section 82A, an issue not now before the House, and that was because she was still under the administrative procedures. It is true that no continuing duty of review applies to other sentences imposed on young offenders, because other sentences do not have the special features of HMP detention. So that's to say discretionary life sentences. That is anomalous. Only it is thought that they should have those features. But in other words, one thing we know is that HMP detention does have those features. There is nothing anomalous in according a monitoring role to the Secretary of State as described above, nor in my opinion is it anomalous to continue to treat a person who committed a crime as a child or young person differently from one who committed a crime as an adult. So that's saying that there's a distinction also between the mandatory life sentence and the HMP detention sentence, although as we now know, mandatory lifers have a tariff and a post-tariff period. In referring to detention during Her Majesty's pleasure, the 1908 and 90 used a form of words first found in the Criminal Lunatics Act, a clear indication that those so sentenced were not regarded as fully responsible. A crime committed by a person who is insane or underage does not cease to be such because he later regains his sanity or becomes adult. And so, although it's quite true, he didn't rule on the express point about 82A. The indication is that the underlying rationale still applies despite any anomaly. And if we look at 82A, 82A does not, in our respectful submission, by judicialising the determination of the tariff, alter the position that the sentence, the overarching sentence, remains HMP detention with the right to a review or a reduction of the tariff. And so we submit, and this is at paragraph 2, that the limits of any inference of change from the introduction of section 82A are clear from the following. Firstly, the absence of any statement in or necessary implication from section 82A of the 2000 Act. The principles and reasoning in Venables summarised later in Smith no longer applied, and that the process of review for those so sentenced should be different. The fact that the rationale identified by Lord Bingham applies with no less force to sentences imposed under the 2000 Act than those previously imposed. So the fact that the judge pronounces sentence in court on principles does not exclude the allowance for a reduction in the sentence. And we say it's not inconsistent, indeed it's consistent with the rationale identified by Lord Bingham at paragraph 15. And then we have the further points that the Secretary of State for Justice and the courts have for 20 years operated on the basis that the principles in Smith continue to operate despite the passing of the 2000 Act, and so did Parliament, subject to some errors. In every decision since Smith, the High Court endorsed and applied the principles in Smith as recognised by the Court of Appeal in Nwankwo. It's just an illustration, and it's a sentencing appeal, but I think my Lord asked how is it done, as it were, and I think the answer is that the judicial view is taken, the Secretary of State then accepts that view, and then the sentence is treated as reduced.
But it's the word treated as reduced that puzzles me. I understand the mechanism. It's not a High Court judge sitting as a High Court judge. It's a High Court judge making a recommendation and subject to judicial review, as far as we can tell. And my concern is not so much mechanism as basis. How can a member of the executive, having had a view from somebody who, in his day job or her day job as a judge, start tinkering with the sentence the Parliament says must be served first, or that part of the sentence that must be served first? That's
well, my Lord, I appreciate that point of principle, but the answer in our respectful submission is that because the rationale of of Smith continues to apply, and there's nothing in the section 82A to indicate that it doesn't. But my lords, my lady, I'm so sorry, my lady and my lords, can I just take you, just by way of illustration, and I don't think it takes it much further, but just to show you how what happens is described in the Wankworth case, and probably in numberless other cases. This was a case where the CCRC had referred the case back, but there had already been a reduction of the sentence, and it's referred to by the Court of Appeal Criminal Division in the judgment of Lord Justice Davis at paragraph 25, early in 2021, as he was then entitled to do.
Which tab?
This is the Nwankwo case, which has been handed out, my lady. It should be at the back of, I hope it's at the back of your note.
Yes.
Of my lady. So it's paragraph 25.
Yes.
So at 25, early in 2021, as he was then entitled to do, the appellant applied for a reduction of his tariff or minimum term pursuant to principles in Smith. For the purposes of the application, he was assessed by Dr. Anna Pascal, a consultant psychiatrist. Dr. Pascal assessed him further in November and December 20 to provide, and then it deals with that. And then the result is at referred to at paragraph 41 under the heading conclusion. As we have already mentioned, the appellant's minimum term was subject to review by reference to the provisions of Smith. In 2023, Mr. Justice Johnson, by reference to the criterion Smith, found that the appellant had made exceptional progress. He reduced the minimum term by 8 months so that it currently stands at 15 years and 4 months. This is the minimum term of which we are now concerned. So, as it were, there's no doubt the end result was that the minimum term had been reduced, but my lord is right that in the end that was through the mechanism of the Secretary of State.
And in that case, no doubt like many others, an assumption was made about the basis for it,
Yeah.
but that assumption wasn't examined in the way that
I have to accept
we're now looking at it now.
my lady, I have to accept that. All I can say is there is a reference to what actually happens is it's treated as reduced, and the sentence becomes the reduced sentence, and on which they then had to operate the early release provisions. So my lord is of course right that there is no formalised process, but that is what happens. Of course, now that Parliament has said a formalised process will occur, our submission is, and I know the court has that there should be no discrimination in the application of that as between those subject to the sentence from the word go and those who are sentenced, sorry, they're all subject to the sentence from the word, those sentenced before they reach the age of 18 and those sentenced after they reach the age of 18. So our simple submission at paragraph 3 is that section 82A 1 and 7 do not turn the sentence of detention during its
That's not quite what I said. I mean, I've been very careful to say the way in which the sentence operates. No one is suggesting it's become a life sentence. It's treated as equivalent to or in the same way. And it's the way in which the sentence operates, but it's the same point. But it wouldn't be right to think it's just a linguistic point.
No, well, my lord, it was just to put in context the point about the life sentence, and if it's of assistance to the court, that's the reason, and it's been there since 1997. It's so section 82A provides this section applies if a court passes a life sentence, where the sentence is not fixed by law or the offender was aged under 18, he committed the offence, and then that is defined in subsection 7. In this section, life sentence has the same meaning as in chapter 2 of part 2 of the Crime Sentences Act, and then section 34(2)(b) provided and has provided since 1997 that in this section life sentence means any of the following imposed for an offence, and B is a sentence of detention during Her Majesty's pleasure. And I've made my submissions to the court, which is that was a shorthand to indicate those indeterminate sentences to which the provisions for determining the first date of parole would apply. In 1997, it was discretionary life sentences and HMP detention, but it's been expanded since, as one can trace through with the various reenactments. And a sentence of detention during Her Majesty's pleasure is included for those purposes in the definition of life sentence. And so the 2000 Act did nothing new insofar as it said HMP detention was to be included in the definition of life sentence for certain procedural purposes. And the 1997 preceded the decision in Smith. That's my submission, but as to the history, and we therefore respectfully submit that Section 82A does not change the nature of the sentence, and even if the court is troubled by the mechanism that was adopted for 20 years, now that Parliament has sought to put it on a statutory basis, there is no justification in our respectful submission to discriminate between those sentenced before their 18th birthday and those sentenced on or after. And that applies because of two factors. They're both sentenced to detention during Her Majesty's pleasure, and they're both sentenced because their offences were committed before they reached the age of 18. My lady, those points I'd made yesterday, but I just briefly reiterate them. And then as to the continuous or continuing reviews, just to make clear our position, we respectfully submit this as paragraph 5. The duty of review or availability of reduction does not mean a duty to continuously review. It requires merely that there must be an opportunity for reduction in the event that progress and maturation calls for the term fixed to be varied downwards. That's a direct quote from the Smith decision. And we say that proposition, that principle still holds good, that it must be reducible if progress and maturation call for the term fixed to be varied downwards. And then next at paragraph 6, we make the point that we don't invite this court to go beyond the point that the absence of any and all opportunity to seek a reduction is a breach of convention rights. We have not put the question of further reviews in issue. I appreciate the court may wish to look at the overall picture, but our simple proposition is that to deny all reviews is a breach of Article 14 and indeed of Article 5, and in the case of this particular applicant, of Article 7. And then very briefly, returning to Article 7, the court raised yesterday the issue of the status of the tariff or minimum term as part of a sentence of detention during Her Majesty's pleasure, and our submission is that the minimum term is a penalty for Article 7 purposes. It defines the outer limits of punishment or punitive detention. In other words, once it's fixed by the judge, it cannot be increased. So to that extent, it fixes, that's the limit of punitive detention. But it can be, because of the special nature of the sentence, reduced, and indeed under the statute.
Well, it's not the limit of punitive detention, isn't it? But the limit is life. I mean, certainly the minimum term you're entitled to go to the parole board after that.
Well, my lady,
How would you?
Well, if one interprets it as the courts have, as analogous to the sentence imposed on criminal lunatics, the moment you have concluded the punitive phase of your detention, you are in the purely preventative exercise, and life is no different than a discretionary life. So you'd never say of a discretionary life sentence in the post-punitive phase, you're being punished. You would say it has two phases. This is all the European court cases. The first is punitive. You've completed that. You are now in the preventative phase.
I think I was taking issue with the proposition of this, or the outer limit of the sentence, which it plainly isn't.
No, it's the outer limit of the punitive detention. of that penalty phase. So, but it is significant that if one's saying what is the punitive phase of the sentence, the judge fixes the outer limit of that in open court at the hearing. He does not exclude, by doing that, the possibility of reduction in accordance with that's a simple submission. But it is important because when it's said in Article 7, no, your penalty is HMP detention, that hasn't been increased. The European Court says you've got to look at the substance of it, and so indeed does the English cases following that. You've got to look at the substance of it. The substance of it is it is a two-part sentence. The first phase, the punitive phase, the penalty phase, is you've got 10 years as punishment. The second phase is purely preventative detention.
I don't see the difference in substance between a situation where you've got a minimum term or a standard determinate sentence and you change the amount of time that they serve before they can apply for parole. The standard determinate sentence is where you increase it to 2/3 instead of half. That's not a breach of Article 7. And here you've got a minimum term which sets the punishment level, and you're allowed, if you're under 18, to ask for that to be reduced. But it doesn't mean that the penalty is not the minimum term. It means the penalty period is the minimum term. Yeah. And so long as you're kept in prison for that period, that's lawful. And nothing wrong about that. So you're not increasing or changing either the sentence or the minimum term. You're simply giving somebody the opportunity to apply.
Well, my lord, in substance, and I know in the end this is a question of definitions. I accept that, my lord. But if one looks at it from the point of view of, is the penalty that's imposed, does it have this unique feature of reducibility at the time it's imposed? That is our submission. That although the punitive detention is fixed by the judge, and that fixes the outer limits of it, it is always a reducible penalty. It has that unique feature. What is removed from this claimant halfway through his sentence is that unique feature of reducibility. And we say that to remove a unique feature of reducibility is to actually change the penalty and harshen it. It's different from altering the parole terms, because when you alter the parole, the sentence remains the sentence. You just get out sooner. If you alter remission, the sentence remains a sentence, but you get remission. But this is a reduction of the sentence, an alteration of the sentence, so that the new
to reflect things which have happened subsequently.
Well, I accept that, my lady, but in accordance with the rationale from the start. So it is, but it's helpful that one has in the European courts analysis a distinction between those cases where the penalty is redefined, and we say that's what happened in this case with the introduction of the Act excluding the reducibility for those sentenced after 18. They redefine or amend the penalty. My learned friend says that's what's happened. They've redefined or amended the sentence of DHMP for those in that small class. And so the European Court does draw a distinction between cases where it's simply early release on parole, where you redefine or amend the penalty. And we say that we're on the Article 7 offensive side of that line. And so we make the point at Roman 4 that the effect of making the tariff of HMP covered by 27A11 irreducible is to turn the nature of the sentence into that of an adult sentence. to custody for life or life imprisonment. It changes it into effectively indistinguishable from a sentence imposed, a mandatory sentence of custody for life or life imprisonment imposed on an adult. And we say that's clearly an identifiable change in the nature of the sentence. And yet the distinctive sentence of DHMP is based on the lesser culpability of juvenile murderers. My lady, the only final point is that I've drawn attention to the fact that there was apparently no consideration given to the particular position of those who were in the pipeline, as it were, who had for many years been under the clear impression and expectation that they would have a review with a view to reduction, and that has been taken away from them. And that happened to this respondent. Firstly, despite the fact that his first appearance in court was on 16th of May, 4 days after the offence, when he was still only 17 years old. So he hadn't, the court process itself had begun before he reached the age of 18. And also that from the time when he was sentenced in June 2015, he had many years anticipating that he was serving a reducible sentence, and then had that sentence changed in that respect fundamentally on the basis of the subsection 11. So, my lady, my lords, we say that that is a particular feature of this case, not addressed by Parliament, not addressed by the Secretary of State in the White Paper, but offensive to, first of all, common law notions of non-retrospectivity, and secondly, to Article 7 itself. My lady, I'm now going to hand over to my learned junior to deal with one or two further points that we failed to deal with yesterday. Oh, I failed to deal with.
Yes, Miss Woodrow, thank you. Thank you, Miss Fitzgerald. Yes.
Maybe 3 very short points. Could I reassure the court? The first is just to provide some reassurance, I hope, on the procedural concern that was raised by the court yesterday in relation to the evidence that was not admitted in the court below. There was an application made in the respondent's notice. It's at sections 6, 7 and 8 of the respondent's notice at pages 36, 37, 38 within tab 4. That application having been made in the usual and proper way, the court contacted the parties to ask whether or not this needed to be dealt with separately. The proposal was that it be dealt with at the hearing. And it was asked whether or not that would affect the time limit. All parties agreed that it need not, because it was inevitably bound up with the substantive issues before the court.
The two things, you say you've applied,
Yes.
but it's not an application, it's an appeal, isn't it? Don't we have to be satisfied the judges below were wrong? It's not like fresh evidence which hasn't emerged until this hearing. And there's also the 2 statements in the bundle. I just wonder whether they're the same. You're expressly told, no, we're not admitted those, and they've been put in the bundle by someone, and we shouldn't really be doing that, should we?
They were in the bundle because in the respondent's notice, the respondent indicated to the court that we would seek permission for the court to look again at the question of admitting this evidence. The basis for that was that in the court below, the reason that evidence was not admitted was because the court adopted the position advanced by the appellant, that the evidence, particularly the evidence of Dr. Delmarge, went no further than that elucidated in the policy documents and the authorities before the court. That position appeared or appears to have changed on appeal insofar as the appellant now says the case law does not deal with or doesn't provide any answer to the points about maturation that are made. So insofar as Dr. Delmarge is, in fact, goes beyond that, we say, in fact, the court may well have been right. But insofar as it's necessary in scrutinising that assertion to look at evidence beyond, and insofar as Dr. Delmarge isn't already catered for in the other material, we say we should be entitled to have regard to that, bearing in mind the basis upon which it was disregarded in the court below. And the the application was made in this way, the grounds for upholding the appeal, it was made clear that the respondent would seek to invite the court to admit the evidence that was disregarded and to include that in the order that permission should be granted to rely on the evidence that was indicated below. The material was included in the bundle by the appellant, who of course prepares the appeal, and no objection was taken by the respondent on the basis that it was anticipated the issue would be dealt with at the full hearing. So there was no attempt to circumvent the procedural
Do you
mechanisms.
accept now that you should have appealed against the decision to refuse to admit it, and that we would have to be satisfied that the judge was wrong to refuse to admit it?
All in effect, that is, in my submission, what we have effectively done.
In effect, an application.
Yes, in the same way that we have sought to appeal effectively in relation to the dismissal of the Article 7. It's the application effectively is made on the same basis.
And the statements by the two HMP detainees, of course, that's quite different because the judges said they were irrelevant to paragraph 5.
Yes.
So what's your submission if you now are going to appeal that decision?
I accept that and I don't pursue it.
Oh, so we can ignore number 2 in here, can we?
Yes, I think that must be right, my lord. It's not
And
the
Mr.
sentence.
Creighton's statement?
Well, Mr. Crichton's statement, as the court below indicated, goes simply assists the court insofar as it takes you through the jurisprudence of the High Court in the minimum term reviews. It's probably dealt with by reference to our Annex A that we've provided, so the court need not have regard to it by way of evidence. It's essentially to assist in relation to what the minimum term reviews
What is
are.
it? I mean, it's got to be something. Are you appealing? Was there a decision to refuse to admit it? Are you appealing that, or are you not now appealing that?
We don't pursue that by way of an appeal. It's not necessary.
Right. So it's only Delmarge that you say the judge was wrong, or the judges were wrong to refuse to admit it.
Well, what we say, my lord, is this. We don't, in fact, necessarily say that they were wrong. What we say is this. I'll come to why I say this is an exercise that is both permissible and proper. But in inviting the court to scrutinise the proposition underlying the differential treatment, the court ought to have regard to, in effect, the correct and the sound factual position. The court below was, in fact, we submit, right to reject that proposition based on the material that's already before the court. However, if, as the respondent now suggests, Dr. Delmarge adds something to that, and that is necessary in order to deal with the proposition advanced as a justification for the differential treatment, then we ought to be able to rely on it. And I'll take the court to Matheson in relation to what the court can do when looking at evidence when scrutinising the propositions underlying differential treatment. So that's how we put it. It may well be that the court doesn't need to deal with it. If the court is satisfied, as the court below was, that the matter is wholly covered by existing materials, then we don't need it. But we shouldn't be prevented from relying on it if, in fact, the assertion is now made, contrary to what was asserted below, that the case law doesn't go as far as Dr. Delmarge. And if we need it, we should be able to rely on it because...
The last difficult question then,
Yes.
Is it expert evidence?
We say that it is. If there is a complaint about form, then that's one that we have to accept and confront. But
Can you just I'm sure it's in the bundle somewhere, but just identify for us how this material came to be introduced and at what stage
yes,
it was before the divisional court. I'm sure it is in the paper somewhere, but you could just give me a thumbnail sketch.
yes, of course. It was identified right at the very beginning, at pre-action stage, that there appeared to be, based on the rationale being advanced, some issue or some non-acceptance of the ongoing maturation and the position about ongoing maturation past 18. In light of that, in our pre-action correspondence, we sought to summarise the overwhelming consensus in what was then called an Annex A, which is at 16A of the bundle, core bundle, page 262, which ended up being appended to our statement of facts and grounds. the appellant was invited to indicate whether that was agreed or disputed, so that the claimant, as he then was, could seek to make good those propositions if they were in fact controversial. There was no indication that they were controversial, and so the parties proceeded on that basis. When the response and further detailed grounds came through, the position nevertheless appeared to be maintained that in fact relevant maturation ceased. And that continued to be-
I mean, obviously we don't want
yes.
to go below the Paleolithic layer in relation to this issue, but it does contain quite a lot of assertions, Annex A, doesn't it? I mean, and
The
normally
purpose of it,
the process of judicial review doesn't include expert evidence or controversial evidence
yes,
in this
precisely that
way.
point, in fact, my lady, that we were seeking to avoid, because these are uncontroversial propositions.
Your submission is that they are.
Well, they are propositions which we say are overwhelmingly established by reference, including to the case law and policy concessions, including in the framework policy document that the court has in the bundle. What we were seeking to do at this stage was to establish whether or not this was controversial, because it is litigating in this area. One recognises that these are things that are time and time again accepted, endorsed, recognised as being uncontroversial. So the purpose of Annex A was to set out what we said was the uncontroversial position and invited the appellant to indicate if there was any dispute about them. No such indication was given.
They don't have to. You don't run litigation by saying, agree on our case now, and if they don't say anything, say, well, there we are, we asked them to agree it, and they haven't, so we assume it is agreed.
The purpose of seeking to understand their position, which is really what we were trying to do, whether or not this was in dispute or not, because it's accepted on the one hand in the appellant's own policy documents that relevant maturation continues past 18. This is not a singular event. Entry into adulthood passage has already been cited by my letter from Mr. Fitzgerald, King's Counsel. So on the one hand, you have that acceptance, and my lords and my ladies have already seen other references to continuing maturation in the various documents in relation to this bill as it then was. On the one hand, you have those assertions, but on the other, you have a justification that's advanced on the basis that no significant maturation continues past 18. That tension was one we did not understand. We sought to understand what the appellant's position in fact was in relation to the underlying factual premise.
I mean, I think the formal position is that if you, as my lord says, I mean, if the position is that you want to rely on expert evidence, unusually in the context of JR, then an application would have to be made for the court's permission to do that expressly.
So that is what then followed, my lady.
Was an application made to rely upon it as expert evidence? It was.
Is it in the right form? Does he confirm that he understands his duty to the court and so on?
I think it's right that the declaration is missing, and I have to accept that.
So, okay. And where's the applications? Have we got that?
I don't think that is in the bundle. Oh, I'm grateful to my supplementary bundle tab 9. It may be that in fact this is, I'm setting a hair running that need not be resolved, because as I say, our primary position is that the matter
We're asking you questions, so what page is it, did you say?
Supplementary bundle tab 9, application notice filed by the respondent. Related not just to Dr. Delmarge's evidence, but to the other evidence which my lord has already referred to, and which is of less significance at this stage and we don't pursue.
All right, so we can see the application at page 235. All right, so where are we now?
that was just to deal with the procedural how we got here, my lady. Just to reassure the court in effect that this hadn't been slipped into the bundle by the back door in effect. There are two substantive points.
Yes.
The second of which is perhaps of relevance to the discussion that we're having about Dr. Delmarge, but if I might take them in this order nonetheless. The first issue that I just want to address is questions that arose yesterday afternoon in relation to the chronology of the documents, the white paper and the
Yes.
government documents. And I think that the issue my Lord was particularly interested in is what that illuminated about the state of understanding about the availability of reviews and how that developed and when. So I just seek to try and assist taking my Lord through that. The first government memo before the white paper, that's at page 93 of the supplementary bundle. All of these documents are in the supplementary bundle and they're exhibited to the witness statement of Mr. Webster at tab 8.
Yes.
But the first memo was produced on the 17th of July 2020. That document, amongst other things, proposed that paragraphs 35 to 42, the restriction of continuing reviews post-18, but there was no proposal at that stage to remove all reviews based on the date of sentencing. So that doesn't, this notion hadn't arisen at that stage. Thereafter, that's the 17th of July 2020. Thereafter, on the 20th of September, the white paper was produced, and of course it's that document that is then presented to Parliament. That white paper, my learned friend Mr. Watson's King's Counsel has taken you to, the relevant paragraphs being 329 and 330. And that operated on a misconception that those sentenced after 18 were not entitled to reviews. And of course, that being the case, no justification for that position was proffered. The explanation was the lack of accelerated maturation and change compared with children. And of course, at 3:30, no significant change occurred. So that's the rationale at that stage, but there's a misconception about the availability of reviews. On the 16th of October 2020, and this is the document my Lord was looking at with Mr. Fitzgerald, King's Counsel, which so that then comes after the white paper, the Minister of Justice had requested further advice, and in that advice, the question of removing reviews based on the age at sentencing was first considered. And as to what the law required, it seems...
SB 93. No, that's not, no.
Sorry, 93 was the first memo that didn't deal with...
this one then?
The 16th of October memo is then at it starts at page 218. But if my Lord goes to page 220, paragraphs 16 and 17, the advice and the legal understanding appeared to remain that those who were sentenced over 18 were not in law entitled to reviews. And the advice was that, in fact, it clarified that the policy had been affording reviews to over 18, but there seemed to be the belief that the law itself somehow distinguished between those over and under 18. And so the advice was that the policy...
I'm sorry,
thus
it's my
far-
fault.
Forgive me.
The noise, I'm afraid, we're competing with here. Which paragraph would you like us to look at?
So paragraph 16
Yes.
sets out what was 329 of the white paper,
Yes.
that they're not entitled to reviews. That's then addressed at 17 below. It says, scrutiny of this statement post-publication has highlighted an inconsistency between our legal position, which is that the case law does not give the right to review to those sentenced over 18. They seem to be saying that the law makes some distinguishes in some way between those sentenced before or after 18, which we say is simply wrong. But it clarifies that the policy to date had been to offer those...
It is really policy, there is no statutory right prior to the Act that we're looking at.
No,
It's
there's
presumably a policy, and you have a legitimate expectation that you be treated in accordance whatever the policy is at the time.
I don't think it's ever been suggested there's a statutory right. The what has been the law that's being referred to, if my lord goes back a little to paragraph 13, the law that's being referred to is Smith. What they're saying is, our understanding of the law is that Smith doesn't apply to those sentenced over 18, and we say that's we can't understand that position. We say that's obviously wrong, not least by reference to the fact that Maria Smith was herself over 18 when sentenced. So the suggestion that the law, i.e. Smith, didn't apply to those over 18, and the assumption in this
Well,
document...
we've already just looked at, haven't we, the suggestion that this, the point which Mr Fitzgerald dealt with which was that Lord Bingham expressly said, I'm not dealing with the position.
Yes, I
Section 82.
I don't seek to address whether that's right or wrong. You have our submissions on that. But
Okay.
as far as the understanding as it was at this stage, and I'm simply trying to track what that was,
It's very helpful.
is that the understanding in common with everybody over the last 20 years, including the courts and the Secretary of State, was that Smith did apply, notwithstanding the 2000 Act, but that in some way Smith nevertheless had no application to those sentenced over 18. And therefore the conclusion is, the last sentence of 17, that the policy that has been enforced thus far has therefore been more generous than that is what is legally required by case law. So case law requires reviews, but not for those sentenced over 18. But we've been doing it anyway, and we've been more generous. That's the understanding. We say that's an incorrect understanding, but insofar as relevant, that's the understanding. That position appears to be maintained and appears to be the final position in relation to the advice given to the Minister, because it's repeated again when further advice is sought on the 11th of December. And this, my lord, is at page 228, AW16. So this is the third advice requested on the 11th of December, and paragraph 9 effectively repeats what we've just considered in paragraph 17 of the previous document. So,
Paragraph 8.
sorry, paragraph 9,
Paragraph 9.
yeah,
Which page? I'm sorry, I missed it.
sorry, page 228, it
228.
says, our legal position is that the case law does not give the right to review to those sentenced at or over the age of 18. We say that's just wrong, insofar as the case law applied, and that's the point my lord makes, and you have our submissions about it, but they thought the case law applied. We agree. If it did apply, they say that it didn't apply to those sentenced over 18, and we say that is simply wrong.
You would say it's wrong anyway, because either Smith has been
Yes.
qualified by the
Yes.
2000 Act for both under and over 18,
Yes.
and there's no continuing review.
Yes, I mean,
So, yeah.
yes, precisely so, my lord. If 2000 means that Smith no longer applies, then there is no distinction anyway between those over and under 18. This is, on any view, it's wrong. We say it's wrong because Smith did apply and it applied to those over 18, but my lord is right, it's wrong either way.
The problem then is this isn't a judicial review of the Minister, it's a judicial review of the Act. And the question is, one thing we haven't seen is the long title of the Act. The bill introduced, the statement introducing the Act and saying, which is the point, we don't know anything about whether or not parliamentarians were even aware of this hotly debated issue in the corridor of power.
Yes, I agree. Firstly, the reason I address it is because it came up yesterday, and you'd asked. But when one then looks at what Parliament had before it, it had the white paper, which had the even greater misunderstanding before it. And by the time it's then debated in Parliament, I think I have to accept that as far as some of the speeches made by the opposition member, it does appear to refer to an entitlement to review to those sentenced over 18. But, no, and what this court is looking at is justification. There remains at no stage anywhere, either in the various white papers or the white paper rather, or in the debates, there remains nowhere a justification advanced at any stage for the removal
But
of
this
abuse.
is an area that's already been dealt
Yes.
with by Mr. Fitzgerald.
Oh no, absolutely. But as far as the understanding and the error, it appears that this may have been maintained insofar as those seeking to justify it and advance it. That's where we get to. So that is the position as far as the understanding of the existing entitlement. The final point I just seek to assist the court with comes back to the use to which evidence may be put. And I use evidence, if I may, in the broadest sense. I include Dr. Delmarge in that, but I also include the various authorities, the jurisprudence and experience of the High Court exercising their jurisdiction pursuant to Smith. The case that I seek to draw to your attention is the case of Matheson. That case concerned a measure under which, a legislative measure under which allowance paid to the parents of disabled children ceased to be payable if the child was a long-term patient in hospital rather than being cared for at home. That was the subject matter. It's in the bundle, but I don't in fact seek to take you to Matheson because the approach that I rely on is very neatly summarised by Lord Reid in SC. So that's what I seek to take you to. That is at page 547, tab 14 of the authority. Paragraph 89, and then in fact the passage that I invite you to look at is just over the page, and Lord Reid is describing the approach of the court in that case. Before we go to it, it's worth highlighting just at the outset that this was a case concerning considerations of social policy and the allocation of financial resources, which is an area unarguably which requires the widest possible margin of appreciation. So this is an exercise involving a case with the lowest possible level of scrutiny and the widest possible margin of appreciation. The approach, which is, as I say, neatly described by Lord Reid, is described at 548 in the middle of A and B. It begins, Lord Wilson, in a judgment with which the majority of the court agreed, began his discussion of the question of justification by contrasting the basis upon which the legislation had been made, namely that the disability needs of children in hospital were met by the NHS rather than by their parents, with the evidence before the court. That evidence demonstrated that the personal and financial demands made on parents who helped to care for their disabled children in hospital were at least no less than when they cared for them at home. So what the court in Matheson did was look at what was the factual premise or the principle, the justification relied on, and looked at whether it was sound. Was it in fact an accurate position by reference to the material available? In fact, the evidence that the court looked at in that case was reports produced by campaigning charity organisations, and the court recognised that those couldn't properly be described as independent. But nevertheless, the court went on to make the point that there was no evidence set against that position. So the evidence, in effect, overwhelmingly pointed to the conclusion that the premise and the principle on which the differential treatment was based, i.e. that it costs less for parents when their children are in hospital, was simply wrong. It was unsound. And on that basis, the court found that the differential treatment couldn't have any reasonable foundation. They went on to look at international law obligations, but that was not the ratio of the judgment, and Lord Reid says as much in the following paragraph. So it was this scrutiny that was applied to the proposition underlying the differential treatment to see whether or not it was sound.
Was Matheson delegated legislation made by the minister?
It was delegated legislation, but it was subject to an affirmative procedure, and therefore it was legislation adopted by Parliament, but it was delegated legislation.
Well, I'm not talking about the phrase legislation adopted by Parliament. It was legislation, delegated legislation made by the Secretary of State, and it was subject to an affirmative procedure.
Yes.
But you're then looking at the that is a judicial review of the minister then, because it's his or her decision to make that delegated legislation. You haven't got the difficulties there that you have with a corporate body like Parliament and with Article 9 of the Bill of Rights.
Well, the court very, very clearly is exercising, it is conducting an exercise under Article 14 at this point in the matter. So it is, in my submission, authority for the proposition that the court can identify, as my lord has during the course of this hearing, identify what it is that is said to justify the differential treatment. In our case, why, when you have two children treated differently, what is it that is said to justify that differential treatment? The answer that we have in this case is that set out at 329, and I'm going to invite you to have a look at what was said below so that my lord and my lady can see what it is the divisional court was in fact responding to in their judgment. But what, in essence, the proposition to be scrutinised is that no significant change occurs past 18, or that, as my lord put it, the bulk of the relevant maturation is substantially or effectively completed by the age of 18. The logic of that proposition was explained, perhaps more fully, in the court below by the appellant, and it's at page 21 of the core bundle, my lords, my lady. Paragraph 50. And this is a passage that is a direct copy paste from the detailed grounds of resistance. So it's a consistent and maintained position. The logic is that because no significant or relevant maturation continues.
So are you page 21, paragraph 21? Or?
Sorry, 121, sorry.
Oh, sorry, 100, sorry.
Paragraph 50 of the appellant's skeleton argument below. The reason I take you to this is because it makes clear what in fact the justification is said to be on maturation point is said to be relevant. This is the justification that the court is invited to apply scrutiny. We say close scrutiny, but in any event, some scrutiny to. And so the propositions are that because relevant maturation doesn't continue past 18, say relevant maturation doesn't continue past 18, I think the word is significant in the white paper. The underlying purpose of reviews does not apply with the same force. And secondly, that consistent with that, a tariff review of somebody in the respondent's position, i.e. who was 18 when sentenced, will, quote, necessarily be less likely to identify any further developments of such significance that they affect the terms of the original tariff imposed. Now, what I invite you to do, per Matheson, is to look at those propositions and ask whether they are sound by reference to the material that the court has. Our submission is that they're demonstrably unsound.
That would be quite a remarkable thing to do, that we would then be looking what Parliament has said, and we would be saying to Parliament, no, we disagree with you, and you're wrong. Adults go through the same stage of development, 18 to 25, as children do, or sufficiently similar to make it no difference. And surely from SC, what we have to get is whether or not Parliament has considered the matter and give weight to that. And Parliament may have taken the view there is a difference between a child of 10 and an adult of 18. There's a sentencing regime which bases sentence on date of conviction or sentence, and taking everything in the round and looking at what is being given by the statute, that was acceptable. We can't surely say whether Parliament is right or wrong as a matter of fact or expert evidence.
My lord, we don't accept that the limits of the court's inquiry under Article 14 is simply to ask whether Parliament has made a decision.
No, that's a relevant factor. If they've never considered it,
That also
then
is
it's
a relevant
different.
factor.
That would be a relevant factor that makes it more likely that a court might intervene. But when they've considered something, do we then look at what they say and say, no, you're just plain wrong on that? We disagree.
Well, to some extent, of course, we say that Parliament hasn't considered all of the issues, and you've had our submissions on that.
Yeah.
But dealing head on with my lord's question, we say that the court is entitled to look at the justification being advanced, and of course the burden is on my learned friend to do so. The court is required to consider whether that provides a, quote, reasonable foundation, justification for the differential treatment. Not whether the differential treatment has been arrived at by Parliament, according to...
I understand that.
But, and it may be that there are cases where there is reasonable room for disagreement, and this is a political judgment to be made, and one can well imagine many of those sorts of cases. But in this case, what you have is a principle or an assertion, a factual proposition, which is demonstrably wrong by reference to all evidence and authority.
It's your submission that it's wrong.
Well,
and in relation to the, I follow the point you're making, but we're dealing with an appeal.
Yes.
And there was no suggestion that this issue, as it were, needed to be dealt with in advance. So the position we're in is that we have a statement which you've already referred to, and the judgment of the divisional court.
Yes.
The divisional court did not take account of that statement for the reasons it identified,
yes.
And we have no... We're being invited to decide upon its admissibility at the same time as deciding whether to place any weight on it, which seems
Yes.
to me, first sight, not to be very satisfactory,
Oh.
quite apart from the size of the issue which you are inviting us to provide an opinion on, which may, for all we know, invite a huge range of differences of expert opinion. We're not in a position to say, surely. We don't have the, if I can put it this way, the institutional competence at this stage to deal with that very large question.
Well, my lady, can I deal with it by setting aside Dr. Delmarsh for these purposes? The position, what the divisional court did and was entitled to do and was required to do, we say, was to apply some scrutiny, as in Matheson, to the proposition relied on as justifying the differential treatment. And for the reasons they identified, we say they were entirely right to reject that proposition as providing any reasonable foundation for the differential treatment. It is no justification to say that it's okay to treat those sentenced over 18 differently on the basis that they are less likely to benefit from that procedure because they don't mature. That's...
But is that sort of thing significant? I mean, you've got a rule for the 10 to 18-year-old. Criminal responsibility is still 10, isn't it? So you've got a rule for 10 to 18-year-olds, and you've got adults who are being sentenced. And I fully understand all the facts of this case that show in stark terms that is. But to say we're going to create a system that says we'll have date of sentence and people going through the system as adults are in one position, and you have to have a rule, which is a bright line rule. But for 10 to 18-year-olds, we're going to have something different because that group, because a 10-year-old will be significantly less matured than an 18-year-old, surely.
My lord, I'm just wanting to make sure I understand my lord's point. The differential treatment that we complain of is not simply that adults and children are treated differently. That's not actually what's at issue here. What is at issue, as characterised by the court below, with whom we respectfully agree and adopt their reasoning, is the differential treatment based on the age at the date of sentencing. These are two individuals sentenced to the same sentence for the same offence. I mean, in this case, we have a co-defendant, so that it couldn't be more comparable, the positions. And the justification advanced for attaching the differentiation based on age to date of sentencing is because it said, in effect, by that point, the judge will be able to foresee everything that there is to foresee because maturation stopped. And that is demonstrably and unarguably...
Whether the rule is justifiable, the differential treatment in the legislation, what Parliament has legislated for is that if you're over 18, you're treated, at the date of sentence, you're treated as an over 18 and you go through the system. If you're somebody 10 to 18, you have a review, and you might have a further review, but only if you're still a child.
Yes, and that the rationale, the justification for that, which is what I invite the court to test, the justification for it, is that effectively maturation of any relevance is not ongoing.
So what you're doing is you're inviting us to do the same as the divisional court did, although possibly also in addition to rely upon the evidence of Dr.
Only Dr. Delmarge's evidence is only necessary if my learned friend seeks to suggest that the case law does not establish that which we say it does, and that which was accepted to be established by the court below.
I think we've probably explored that sufficiently.
Yes, and of course, my lord has the point in any event that less intrusive measures in any event could have been and should have been adopted, bearing in mind the vice was continuing reviews as demonstrated by the white paper. So it's a separate point. But in any event, those are the matters on which I seek to assist.
We're very grateful to you. Thank you very much. Yes.
My lady, my lords. First, on my homework, and this the question my Lord Justice Lewis put to me after consider this morning, what was the basis upon which the Secretary of State gave effect to the recommendations of a High Court judge to reduce a tariff in a DHMP context. It was a reduction, right or wrong, in the exercise of a general power of executive clemency. And I think the most straightforward way to show that in the materials that we have already is in Cunliffe. But I don't know whether that's made it to the back of your authorities bundle, but it was, you may recall, it was served the day before the hearing. One of the four authorities. Well, Justice Bean and Mrs. Justice Carr, she was then.
Yes.
So just starting at paragraph 5, and this is only because it's a relevant case, if you like. It fulfills the criteria, and there was some evidence from the Secretary of State in it as well. So paragraph 5 sets up the issue of the application for what's described there as a review of the minimum term, and then what happened on the facts, the application being placed before Mr. Justice Mitting, and then the decision, 7, the recommendation of the High Court, no change to your current tariff, and then 8, the decision was taken to accept that. That was, of course, then the subject of this challenge, but through to paragraphs 25 and 26. This is a reference to the evidence that was before the court then, from Mr. Howell, the team leader of the Public Protection Casework section of NOMS.
Where are you?
I'm sorry, paragraph 25.
Paragraph 8 is quite interesting, isn't it? That's about tariff, is it? Yeah.
Yes.
So that's a tariff. So paragraph 25.
That's right. So that was the policy that applied then. So recommendation made, undertaken by the Secretary of State to apply that. 25 explains the background that when considering how best to give effect to the judgment in Smith.
So I'm still obsessed by paragraph 8. How can that be a policy? I thought 2000 we'd had the Act.
We had the Act.
So how are they saying they've got a policy? Doesn't the government have to comply with the law?
Can I?
Anyway,
I think
the
that
I don't
it may
understand it.
resolve the,
Okay.
at least I can explain the position that was adopted.
Yeah.
I accept it wasn't tested, but at least it was considered in this judgment.
Yeah.
So paragraphs 25 and
Yeah.
26 explains, considering how best to give effect to the judgment in Smith, Secretary of State was, quote, reluctant to take decisions on reducing tariffs without judicial advice. Encouraged by the House of Lords' comments on the role of the Lord Chief Justice previously, we agreed a very similar process whereby cases would be referred to a senior judge who would recommend a new tariff that would be endorsed by the Secretary of State in all cases.
So they are talking about tariff as meaning the reduced minimum term, are they?
Yes. And then 26. Yes, and then 26 added that the entitlement to apply for review at the halfway point of the minimum term in the case of detainees sentenced before 30th of November 2000, of course, that was they were carved out, if you like, in Smith, was subsequently extended to all DHMP detainees, irrespective of when they were sentenced. What is described and what was being challenged as a blanket policy to accept the recommendations of the judge is at paragraphs 31 to 32. And in particular, so for the claimant, it was argued that A, the reduction of the tariff element of a sentence of DHMP is an exercise of executive clemency, and then further propositions on the implications of that with respect to Article 6. And then over para 35, and then the answer at 36, then considering those submissions, accepted, in my view correctly, that if the blanket policy were indeed unlawful, it would follow that the Secretary of State had a discretion to reject a recommendation of a judge on periodic review, that the tariff should be reduced. Such a decision would no doubt lead to judicial review applications as a matter of routine. And this is going to the point that was raised yesterday by my lord. The third decision maker, the judicial review judge, would then be asked to say that the second decision maker, the Secretary of State, was acting unlawfully in departing the recommendation of the first decision maker, the tariff review judge. I see that as a rather dismal prospect. And then 36, I think the answer, the Secretary of State does retain the general power of executive clemency under one description of the royal prerogative of mercy, usually exercised on compassionate grounds such as grave illness. As Lord Bingham said in Smith, and that's paragraph 13, that procedure could have been used in DHMP cases to reduce, although not to increase, a tariff fixed by the Lord Chief Justice. Lord Bingham did not say the detainee had or should have any right to have the decision second guessed by the executive. And the relevant section is, as I say, Smith, paragraph 13, that might just be worth turning to. So this is authorities 7. And it's between D and F. Beginning by sympathising entirely with the desire of the Secretary of State. Nothing to do with the setting of a minimum term.
So page 317, did you say?
I beg your pardon.
317.
320.
320.
Sorry, 320. Internal page 168.
Yeah.
Between D and F. Introduced by the sentence, I sympathise entirely. And then just between D and E, while it would obviously be wrong for that term to be subsequently increased by executive decision, it does not follow that the same considerations necessarily apply to a reduction, even if pursuant to a review mandated by domestic law. A reduction in the sentence imposed by a court is a well-recognised exercise of executive clemency, if the Secretary of State should prefer decisions, etc. So it appears, therefore, that, that this one extra element I'm reading in, I don't have it in evidence, but I anticipate that the reason that there's statutory basis for giving effect to the change is that it was anticipated when 82A and 90 were enacted that there would be no further review, because that is the premise, if you like, of the argument underlying Smith. I accept it wasn't considered and ruled upon, of course, in Smith, but the premise of some of the submissions, or at least one strand of the argument, is that looking at the pre-November 2000 cases, this isn't going to be an issue because there's not going to be the availability of the review. It seems that subsequently, as a matter of policy, but I accept this isn't expressly stated in the evidence that's before the court in Cunliffe. The policy was subsequently adopted that in fact reviews, the ongoing process of a review mechanism would be applied to those whenever they were sentenced. And in those circumstances, because the legislation hadn't provided for a mechanism, the Secretary of State fell back on what was set out in paragraph 13 of Smith, indicating that this could be an exercise of executive clemency. I think that's...
And in fact, that might be significant, it might not, because it's not actually, because it's inherent in the statute. There's a statutory duty, post 82A. There's a residual discretion, a residual prerogative power, and the statute hasn't exhausted the field, because the next question would be, could the Secretary of State continue to do it now? And there'll be arguments as to whether or not the new Act occupies the field, like the teaser and all the others.
I was just going to get onto exactly that.
Because, oh, right, sorry.
Because when we look at Smith, my respectful submission in response to my learned friend's arguments is that there is nothing, of course, in Lord Binnan's speech to suggest that Parliament couldn't intervene in this area. Indeed, the premise of the analysis was that Parliament had. I accept it wasn't upheld, or there was any indication that was that Act properly and lawfully removed the right of review. But in principle, it was open to Parliament to do that. I could anticipate a challenge to Section 82A or a challenge to the refusal to operate any review process in the light of 82A and 90 would be able to advance a submission. Parliament hasn't directly indicated here that there is going to be a restriction on the right of review. That, of course, is not open, we respectfully submit here, and that's the key distinguishing feature between the 2000 Act and the 2020 Act, because here Parliament has entered the field, and we would respectfully submit exclusively, in the sense that it's occupied it completely. It has provided for a differential approach based on age, and it did that, as I said yesterday, eyes wide open. And that's the key distinction we respectfully submit between the 2000 Act and the 2020 Act. Of course, I accept that that's not the full answer. The court obviously still has to review under Article 14, but it's a different starting point in my respectful submission, because it places Parliament, it places the issue squarely, if you like, at Parliament's door, because that's what's being considered now.
The difference is the prerogative power was not impliedly excluded under the 2000 Act, but it has now clearly been excluded.
Expressly.
And it would now be unlawful for the Secretary of State to advise Her Majesty to exercise the royal prerogative and grant clemency by cutting a chunk off the minimum term.
I think that must be right. It would certainly be unlawful to seek to do that with respect to those who are aged 18 and over on the grounds of their age, because Parliament has spoken on precisely that issue.
Surprised that no one mentioned this for many, many years, but there it is.
There we are.
That's what it is.
No, and that's why I took the court to Cunliffe, because at least it shows some judicial
Somebody's
consideration.
thinking about it, yeah.
So then, in terms of a reply, width and the margin of appreciation, we respectfully submit that a wide margin does apply here for the reasons given by the lower courts, but also on the proper analysis of Clift and Stott, which I'll just turn to very briefly. We respectfully submit that my lady identified the touchstone of the issue yesterday, which is whether detention is capable of being said to be arbitrary, unlawful, or unlawful, not whether you can characterise a measure as arbitrary in its effect. And that distinction, we submit, differentiates between Clift on the one hand and Stott on the other. So if we could just turn briefly to Clift, it's in tab 8. And we have confirmed there was no refault for this case, and that's why we don't have it. But we do have them for Stott. Clift, paragraph 3. The key context in which the issue arose, and therefore we respectfully submit, explains why the wide margin wasn't applied here. The context was, of course, that Clift Cliff's argument is that his continued imprisonment following a recommendation for release by the parole board, which was only on account of the Secretary of State's refusal effectively to accept that recommendation. That was the issue under Article 514, and we submit that it's very clear why that is going directly to the circumstances of his ongoing detention and the question as to its arbitrariness and or legality. It's in that context that 73, paragraph 73, so through onto page 347, the court sets out the principles of its approach to the question of discrimination, and at the very end of that paragraph, on page 347, paragraph 73, while in principle a similar wide margin of appreciation applies in questions of prisoner and penal policy, the court must nonetheless exercise close scrutiny where there is a complaint that domestic measures have resulted in detention which was arbitrary or unlawful, and we submit later in Stocks that is characterised later as a question of fact, have resulted in detention which was arbitrary or unlawful. And we see how the European Court resolved that. 74, not apparent how public confidence in the system of criminal justice could legitimately require the continued incarceration of a prisoner who served the term required for punishment of the offence and is no longer a risk to the public. Nothing further necessarily from Cliff, although I think we saw yesterday the bright lines observation in paragraph 76, which of course isn't an issue here. Turn then, we respectfully submit to Stott and compare and contrast. So this is tab 18. Page 666. And paragraphs 5 to page 666, paragraphs 5 to 8 set out the background facts. And this was the question you see at paragraph 8. As to eligibility for parole, only available because he's serving an EDS, an extended determinate sentence, after 2/3 of his custodial term has been served, then the parole board will be able to direct his release. And the contrast of that was, of course, suggested that there were other prisoners who were released at an earlier point, and there was no justification for the difference. If we turn through to paragraph 96 on page 689, the same reference to the principles, and again the final paragraph, the final sentence of the paragraph, referring back to Cliff, paragraph 73 that we just saw, while in principle a wide margin of appreciation applies in questions of prisoner and penal policy, nonetheless close scrutiny where there is a complaint of domestic measures that result in detention which is arbitrary. And then we see 102, the contrast the court itself drew with Clift. The present case concerns the point in the appellant's sentence at which he'll become eligible to seek early release. This is a question of an entirely different nature, and it's plainly not covered by the court's comments on risk in Clift, since the court there expressly limited its conclusions to quote the assessment of the risk posed by a prisoner eligible for early release. The question whether a person eligible for early posed a risk was under the applicable framework in England purely a factual one on which the length of the offender's initial sentence could have no bearing. The question whether and when a person ought to be eligible for early relief at all is not. Its answer may legitimately depend on policy as well as factual considerations. And we see then that playing out in 107, because there's a reference there which of course didn't exist to the margin of appreciation and its application there. And the conclusion that the policy considerations had been resolved by the authorities of the respondent state. And we do submit here that the issue before this court is preeminently a matter of policy. At its heart, it is the question of striking a balance between the interests of the families of murder victims on the one hand, and on the other, the interests of the offenders. That is very obviously a matter of policy. Here, considered, we submit and resolved by Parliament through the enactment of Section 128, not of course immune from review, but nevertheless any review by a court we submit has to apply that margin of appreciation or afford that margin of appreciation akin to a test of manifestly without reasonable foundation. See paragraph 46 of the Divisional Court and paragraph 160 of the Supreme Court.
I understand that one policy. I wonder, because we've got to look at the Act, not just the white paper, whether another policy that can be gleaned from the Act is that they want sentencing to be consistent and done by age of the date of sentence. So all those who are 18 and are going through the system as adults will be treated as adults. Those below 18 will be given a beneficial first review, another review, but only if they're under 18.
Yes.
And the question then is it legitimate or justifiable, particularly when the reviews in some cases are going to be way after the guy is 18 anyway. If he's 17 and got a 10-year term, he'll be 22 before, 22 before he can apply
Yes.
for a review. And what do you say about that?
Well, my lord, that is the equitable point that I'm going to look at that now.
Sorry,
with
keep
no,
running
not
ahead
at all.
of you.
But
Sorry,
it's in some sense encouraging. I'm going to look at the white paper because that is
encouraged.
because no, only that I know it's an issue that's got to be addressed. That
I'll let you do it in
the
your own
equitable
time.
point arises in the white paper. So if we do turn to that, it's page 199 in the supplementary bundle. Because it may be, I wasn't seeking to be too simplistic, but it may be too simplistic to simply say that it's on that the only issue is the interests of the victim's family on the one hand and the offender, because that's the crucible in which the issue arises. Then the nub of it is the legitimacy or otherwise of drawing the bright line as 18. I accept that that's where it focuses down to. But on the white paper, I should start by urging, with respect, caution and circumspection in looking at this material, consistent with the decision in SC. I'm going to parse it, if you like, because that's been the way that the respondent has approached it, and I do need to address the detail of what was said yesterday on, in particular, paragraph 330. We, though, would highlight at 328 just this short point, that it isn't simply the continuing reviews and the implications of them for victims' families that are highlighted. It is in terms of the existence of the review procedure, which can be extremely distressing for the families of victims. Of course, the point will be a fortiori if they're repeated, but it is the existence that's identified at 328. 330, this has to be approached with some caution, we respectfully submit, because it's in fact dealing with a slightly different set of facts than those which arise here, and therefore doesn't necessarily speak directly to the bright line, because 330 refers to offenders who are sentenced to DHMP as children, so sentenced as children, but have since turned 18 in custody and are adults and have passed the age where significant development occurs. In practice, I think as my lord has just identified, that's not necessarily going to be referring to individuals who are crossing a threshold, and it's a question of, well, if you are sentenced at 17 3/4, this process would apply, rather now that you're 18, this process would apply. Because in fact, if you're sentenced as a child, i.e. under 18, to take the example of a 17-year-old, for example, and you're sentenced to a 10-year minimum term, you have under the statute the ability to apply to seek a reduction of that. You're going to get one review, having been sentenced age 17 to your 10-year minimum term. That, in fact, isn't going to, the availability of that process isn't going to arise until 5 years later. So your 17-year-old gets it at 22. So it's not at the context here of adults, and the reference to adults is in a context where you're considering that review that arises not necessarily immediately you turn 18, but rather at some point thereafter. So it isn't actually addressing the bright line that's posed, that is being considered at 328 and 329.
And this is all about people, the people who will get it, though, are people who are sentenced to DHMP as children.
That's right.
They have since turned 18, they'll still get it. and
Yes.
they only have it once, not twice.
That's
So
right.
this is the limiting the distress on the families by continuing reviews for those under 18.
Exactly.
They remain under 18 at review.
Exactly, but the reference to adulthood in this context is not quite the same.
No, it's not a bright line. No review after if you sent it
Precisely,
after
because
after
it will, in
18.
this context, be a fuzzy line, because it will occur at different ages depending on the age of the offender when sentenced, and of course then the minimum term, and therefore where the halfway point will arise, where they will get their first review. But I do that exercise to address a point raised by my learned friend. But we respectfully submit that circumspection is required here. We've been careful to draw out the propositions that we have from the white paper, but as I hope I underlined yesterday, the key aspect of this exercise we submit is that the white paper has to be read together with Hansard, given that Parliament did in fact consider expressly the particular amendment in section 128.
But
And-
where do we find then the reason or the thinking for a different problem? Now, not the cutting down reviews for those sentenced under 18. Where do we find anything about why you're going to have different rules than have hitherto applied for those over 18?
Well, I think that is at 328, and the reference on the one hand to the distress to the families of victims, that's the first part, but at 329 then, it's the adults do not go through the same accelerated development and maturation that children do. That's the premise of it, and it's picked up, and I accept it's picked up and criticised by Mr. Cunningham. In the Hansard, you see it in Hansard at page 311.
So 328 is still talking about children change, so I'm not sure that we can get anything about adults. The only thinking for the reason why those aged 18 are sentencing is firstly the sentence that's erroneous. They thought that if they were sentenced over 18,
Yes,
they didn't have one, and they thought that was the case because a 10-year-old is different from an 18-year-old, and a 12-year-old is different from a 22-year-old. They thought that explained something that didn't exist, but they carried on with that. Well, we still think it would be a good reason for not having it if we were thinking about it. Is that the process? It's an odd way to develop policy, even in legislation.
Well, we have this saving grace that that by the time Parliament came to consider the issue, the policy was in line with, I accept it hadn't been challenged or upheld by the court, but the policy was in line with the white paper. So the white paper was accurately describing the policy at the time. And you can trace that through in Mr. Webster's statement, pages 71 to 75. But perhaps more importantly, the way that Parliament approached the issue and the premise of the debate was that those sentenced aged 18 and over were receiving reviews, and so this statute was cutting that down and removing it. That's the premise of the debate in Hansard and the basis upon which Parliament proceeded. And as I say, I don't think I need to take the court back to the exercise I did yesterday of demonstrating.
Those over 18 had a review and that was being cut down, and it shouldn't be cut down, yes.
Yes, and that was, and you'll see the reference to the Sentencing Academy in particular, page 311.
Just one last go.
Hmm.
It's old-fashioned. I would have thought that there would have been an opening statement in Parliament or instructions to the parliamentary draftsman which made it clear beyond doubt that one was the family distress point and the other was we're going to have sentencing based on age of date of sentence. There's nothing that we haven't been shown anything,
No.
and you'd have shown us anything if it was there, wouldn't you? I suppose.
The closest scrutiny is in the relevant discussion surrounding the proposed amendment.
Okay.
So that I think is all I need to say on the white paper. So sorry. All I need to say on the white paper. With turning to the other materials, the internal memorandum, we submit that if we go back to Lord Reid, may have to do this briefly, I'm afraid, paragraph 174 in Lord Reid in SC. I'll give page number in a moment. Page 573. There has to obviously be care applied to that which can properly be taken into account. And the three short points we would make are the internal min-subs, the ministerial submissions that are before the court, put there on the basis of candour and cards placed openly, etc., placed upwards. Those, the views of officials there are irrelevant to the issues before this court, and they haven't been put forward by us in support of the justification. And secondly, as part of that, the view of officials as to the law, or what was viewed to be the law post-Smith, and whether policy had in fact gone further than was required by Smith C, which was referred to this morning, pages 221 and 228. Again, irrelevant to the issues, because that is made good because citing Lord Nichols in Wilson, paragraph 64, additional background material may be found in published documents such as a government white paper, or if relevant information is provided by a minister or indeed any other member of either house in the course of debate, the court must also be able to take this into account. But it can't take into account, we submit, that which is in officials' minds or internal documents. And we also emphasise, and this is the third point, the relevant information is not in this context limited to the promoter of the bill or the minister. It is, as identified there, provided by a minister or indeed any other member of either house in the course of the debate on a bill, because what's being considered is, of course, the extent to which Parliament has grappled with the issues that are then being put before the court in a challenge such as this. And that is why we respectfully submit that the criticism, right or wrong, that the Parliamentary Undersecretary failed to engage with this aspect of the issues of the debate is again irrelevant. That would be to criticise Parliament for the manner in which it went about the business of enacting legislation. The issue is actually, as in Lord Reid and SC, is a matter of fact whether issues were before Parliament, whether Parliament confronted them. And we respectfully submit that it did, and in detail, in this instance. Then, I think only two short further points on, both in a sense on the appellant's case. We do submit that there's been no change in the contours of the Secretary of State's case since the filing of the detailed grounds of review, and with respect to the way we put the case in divisional court and here. We submit, there was a suggestion yesterday that we had perhaps led the divisional court into overstatements that it made as to how we put our case, as to whether, and in particular, the DHMP sentence had been amended. If you need the references, you have our skeleton in the court below, page 112, paragraph 25, where we made clear that the point we made was that Parliament had amended the operation of DHMP sentences in certain key respects, including no review of those if aged 18 when sentenced, and similarly amended that feature of DHMP sentence in a particular category of case, and that is, we submit, entirely consistent with the way that we've presented the issues here.
Well, on your submission this morning, Parliament has told the Secretary of State stop using the prerogative.
Well, that's an ancillary aspect of Parliament entering into the field, yes. But I don't think that goes to the issue, that the criticism we make of the divisional court as to how it characterised our case as suggesting a complete change in the DHMP sentencing. On Dr. Delmarge, I'm reluctant to get too much into the details of this, but just I hope for the record that from our side of the fence, as it were, we have always referred to and relied on the white paper, and precisely those parts of the white paper that I've just referred to today. You'll see them in our summary grounds of resistance, tab 15, page 186, and then quoted page 188. We filed our detailed grounds thereafter, of course, post-permission, again referring to the white paper in paragraph 329, which includes the children do not go through the same accelerated development as adults do, which is the core of the bright line justification.
Or is it the other way around?
Sorry.
It's the other way around.
I'm so sorry, did I get the children and the adults?
Yeah.
Yes, sorry, I'm so sorry. Adults do not go through the same accelerated
Yes.
as children, I'm so sorry. White paper, paragraph 329, cited there, paragraph 41. After that, the filing of our detailed grounds, there was then an application to admit Dr. Delmarge evidence, and we objected, and it was said that the trigger for it was our detailed grounds of resistance, and we respectfully resisted the admission on that and other bases, saying that these issues had all been plain from the outset, but also that we were not disputing that maturation continues beyond 18. Secondly, that the white paper and the reference we relied upon was in broad terms, adults do not go through the same rate of acceleration, etc. And in those circumstances, we didn't consider that the Dr. Delmarge evidence took matters any further. And indeed, he noted that there's no single answer to the question of when maturity is reached, and his disagreement was actually confined to 18 to 25-year-olds on the one hand, and those aged 14 to 18 on the other. It's paragraph 4.6. And in that context, we respectfully submit that the Divisional Court was right to exclude Dr. Delmarge's evidence, and there's no basis upon which this court should introduce it now. The field is clear, and all that quite apart from what we respectfully submit would be quite difficult questions as to the appropriateness of reliance on expert evidence in a context where Parliament has spoken, if you like, and it's then being said on the basis of one expert's view, well, that's contrary to my understanding of neuroscience. Just to ask rhetorically, would the Secretary of State then be required to file evidence herself in order to respond to that in support of Parliament's position? It would be a difficult and issue to resolve. But here we submit that the issues are plain, and critically, Parliament was aware of this issue, which is a matter of public debate. Query therefore the relevance of expert evidence, even if in proper form.
Could
And
I ask
resolve
you
issues.
to
Yes.
just also address what the approach of the Divisional Court in relation to that, because sometimes it's been looked at in judgment, but we have that in paragraph 50, but I think there is also reference to the I think to the some of the case law
Yes.
and to the court's own experience as well.
Yes, my lady.
When they look at the general principles of youth sentencing,
Yes,
and somewhere they refer to their own experience.
they do, and the slight complication on appeal is that on the one hand, we don't disagree, of course, with any of those propositions in Peters, Arnold, etc. as I think I started with, well, the second proposition yesterday, was that the sentencing exercise undertaken in a DHMP case is unchanged, and all of the principles identified in Ahmed, ZA, Gafoor, all apply with equal force, notwithstanding the introduction of section 27A. There's a separate and different question here, which is the availability of a right or an opportunity to seek to review that minimum term subsequently.
But it's not being reviewed on the basis of harm and culpability.
No.
It's being reviewed on exceptional progress.
Yes.
I mean, in this Stephen Lawrence case, you had to take into account that the people who murdered Stephen Lawrence, I forget how old they were, but they were
Mid-30s, I think.
No, when they killed him.
Oh, I see, I'm sorry.
I mean, you had to take,
Yes.
they were 30 now, then you,
Yes.
if they'd done it now, they'd done perfectly well, but you had to put yourself into the truth then. But the review, as far as we can see, the policy seems to have been on the basis of criteria of exceptional progress. I should say, all I remember when we did this, you were given the document, the criteria were exceptional progress. We haven't even seen the document setting out the policy that was applied.
I think it's in the bundle.
It's in the bundle.
It
It
is.
is in the bundle, right? Okay.
I can take your.
No, if it's there, I'll find
It's
it
there. I think it's AW4. It's a Webster exhibit.
Right,
and
and
actually
it is focused on exceptional progress,
It's-
not review of harm and culpability.
Yeah, so that's slightly broader than it is now under 27B. I recognise that. There is a distinction. And also the way that it's applied, also in some instances there was though consideration of the original index offending and the seriousness of that. You see in practice that was sometimes considered.
Right, okay, so there may be cases where they hadn't done a harm culpability tariff, and that was
Yes, and
the way in which they did it.
but obviously I'm looking at 27B and have to accept that that's the scope of the basis upon which there can be a review now. Yes. My lady, I'm worried I haven't addressed the issue that you were putting to me.
Well, I was just wondering if it looks at the judgment. We have prior to the discussion a detailed reference to the sentencing guidelines.
Yes.
I'm not sure. I think probably this is all covered by the submissions already made. I don't think I need to. If there's any further question, I need to ask about that. All right.
I think that is. They are. Just give me a moment. I think they are the only points that I need to address arising from yesterday. We do maintain that on a proper application of the margin of appreciation, the divisional court was wrong to find no objective justification here. That's ground one. I don't think there are any matters that I need to address in reply on ground two, unless there are any issues that the court wanted me to cover.
I dropped my pen, that's all now.
Sorry.
I'm just going to rise from it.
I'm so sorry. My learned friend.
Oh, I'm so
might want to
sorry.
focus on Article 7.
Yes,
I'm sorry.
my apologies. Yes, Miss Sullivan.
Thank you, my lady, my lords. Just very briefly on Article 7, the issue between the parties in effect is the proper characterisation of the penalty. Article 7, of course, prohibiting the imposition of a heavier penalty. The Secretary of State's submissions, as you'll have gathered from yesterday, are that the penalty that's imposed is the sentence of detention at His Majesty's pleasure, and not some sub-element of that in terms of the minimum term. It's right that that a minimum term is set, but the penalty for Article 7 purposes has to be viewed as the sentence as a whole. The respondent urges on the court that you should consider that the penalty is the minimum term, or that the minimum term is at least capable of amounting to a penalty for the purposes of Article 7, and because that is not reducible any longer other than as set out in accordance with Section 27A, 27B, that amounts to the imposition of a heavier penalty. The Secretary of State says in response, firstly, that that's the wrong approach. On a proper analysis, the penalty remains detention at His Majesty's pleasure. But secondly, that if it were right to look at the minimum term that's set as the punitive part of the sentence as being a penalty in its own right, it is difficult in principle to see how that should be distinguished from determinate sentences which are set and which were considered by the Supreme Court in Morgan and by the Divisional Court in the case of Khan, in both of which cases the court has held that changes to the reducibility of that penalty amount to measures going to the enforcement or execution of sentence, the penalty, rather than being the penalty itself. And so we'd say even on that analysis, the changes here don't fall foul of the division between penalty and measures amounting to, relating to the enforcement or execution of it.
On your first point, say Parliament did this. They said there's been an outcry about young people with knives. We're doubling every minimum term from tomorrow. Wouldn't that be a breach of Article 7? Every sentence, every minimum term that's been imposed, we're doubling it to make sure that children don't kill each other with knives. Wouldn't that be a breach of Article 7?
My Lord, firstly, those aren't the facts here. There would be, I can see there would be debate about that. If your Lordship's example were, of course, to operate retrospectively. But the sentence would remain, in these circumstances, detention at His Majesty's pleasure, or if applied to adults, a life sentence. And so our primary answer is no, that doesn't amount to a retrospective penalty, because the governing sentence is still there. But if it did, if it was right to analyse it separately, because it's the point at which release arises, the question is whether that would offend.
You say doubling is not the same as an opportunity to reduce. Yeah.
It's not. That's not. There hasn't been an imposition of a heavier sentence here. There's been the removal of the opportunity to apply. So there is a loss of chance. And it is in that context of some significance, or maybe of some significance, Mr. Watson, King's Counsel, has taken your Lords and your Ladyship through what was happening between the 2000 Act and the current changes. If the analysis set out there is correct, that it's an exercise of clemency in effect, that obviously does have some significance for Article 7 purposes when considering whether you're looking at a penalty or a measure relating to enforcement or execution, because what you're losing is the opportunity to request that exercise. My Lord, my Ladies, my Lords, unless there's anything I can assist with further.
All right. Well, we will now rise. Thank you very much. Just for a short moment. Thank you.
Hang on.
Because it's been done properly.
Yeah. Well, this was something.
Important first. My crest.
Apparently we shouldn't say anything. It's all on camera. Well, it doesn't seem. It seems to be switched off.
No, it's green.
green.
Live streaming on.
Oh, I see.
It is still streaming.
It's the Davina McCall. We are
Can you
still
tell
streaming.
whether
Please
everybody's
don't
on
swear.
live
Live in the Big Brother house.
Well, everybody on.
Seven people watching.
I think France is attended by 7 people, like Parliament.
Like Parliament, quite. Seven's a magic number, clearly.
I didn't take you on that.
Oh,
7 people. 7 miserable individuals.
Parliament actively misled by the minister. Everyone will still have reviewed it.
It's very, very cool, isn't it? Is this budgetary constraints?
Sometimes it's extremely hot, so.
Do you have any control
certainly
over which one
encourages
it's going to do?
Certainly encourages one to finish quickly. It's all free. Is it warmer up on the bench?
It is a lot warmer in the judges' corner.
Yeah, that's right.
It fluctuates a lot. I think it's just the old building.
Oh, it's pretty cool. I knew it was too much to make. I get 3 weeks without doing that.
Yeah.
Oh, third and fourth hours.
Performance of the day.
You're not, because I think it's free in case can't. You sort of when you're a junior boss, you sort of think, okay, well, I'm doing it. Maybe I'll get there.
There's some people who are
There's
like
some
that
people
on day
who
one,
would just, well, they're like that on day one, and then they get better. And there's this, it's I don't find it. I mean, it's kind of inspiring, but I don't find it personally inspiring because it's like, well, you can never be that, like there's no sort of, and you too can be as brilliant as that.
Which is yeah. Well, I think Joe is suggesting.
Well, I don't think it's selling itself to say that.
So better to put keep free.
She's the only person in the world.
Clearly, it's not the first one they've done that day. From their expertise.
No,
That's like this.
no.
Like you said, you need expert.
But he's very next to his. He's just going to give you adjectives.
But then offered me an opportunity, which was a Tuesday at 4 p.m. Like, I mean, yeah.
Do you think
Do you know a lot of people want to drink copious amounts of whiskey on a Tuesday?
I will practice
There are alternative times and days available for this.
like an evening, a weekend.
I mean, an evening is one thing. That's when I don't drink whiskey.
She's got a great name.
Cheese can be
Actually, I think Nicholas Willis tried I'm going to just go mention.
I'll show you guys my niece.
Is she new?
She's nearly 2, so she's not that new in the grand in the grand scheme of age of the universe. She's
It's too squishy at 2.
I always don't want to like form an opinion. You have so little information, but you just sort of feel there's no way. I'm so good at that. Anyway, the states.
I'm so shocked there. It seems like
Yeah, so I forgot that.
girl after my own heart.
She knows what she's about. She's cute.
Well, I do.
Yeah, no. It sounds a bit sort of like a box and slightly but
It was great. No, it really, really was.
there's a few
That's Irish twins.
I think husband and wife, let's just get it done. Let's get it done. They need to.
I used to give talks to them. What are they doing? Just you too. I just think it's not like they felt much more like they felt much more like police lawyers than defence lawyers.
So this one we went to Australia for Christmas after wonderful. It was my mother-in-law's birthday. And for her present we got like and then we went to the beach. That's so nice. Oh, my space outside. Oh, yeah, they love like a professional photo shoot because they love dressing up. They love like posing like show ponies. It's nice though. So yeah. Because I've got
You've got one once they are a number of years and it doesn't work.
You move from man marking to zone marking.
What does that mean?
So instead of marking the triangles, you mark the tenuous spaces.
Really?
So the doorway represents the first and last line after that is your door.
But once they are tall enough to open the door, difficulties.
That's why the door has 3 locks.
3 locks, one for each of them.
And I mean, they're 3, 5, and 8. So. Yeah, because we're little teenagers.
One of my friends has 4 children and he stayed at home.
You know, children Gordon days.
Yeah, 6. Because I was taking it and he said he's got 5 and he says 6. Like that. 6. Big smelly household. We better just send messages on Teams.
Watson, Mr Fitzgerald, Ms Woodrow and Ms Sullivan, can we thank you all for your submissions in this case. We're very grateful to all of you for helping us in this interesting case and all the points that we have to decide in relation to it. You will understand, we will provide you with a draft of our judgments for the correction of typographical errors, etc., not for re-argument. If we require further assistance, we will ask for it in writing. We would invite the parties to endeavour to agree a draft order for our approval prior to the handing down of the judgment, which will be done remotely. Obviously, if we require any further argument, we will ask for it. Right, I think it only remains for me to repeat my thanks to everyone concerned. We'll rise now. Thank you.
All rise.
It's off.
I see something that was, I think they were thinking of asking for further submissions or something.
Yeah,
Because you don't normally get that if you're
No.
going to get further submissions, you want them in writing.
They might, one thing that was troubling me.
Yeah, that's
Yeah,
right,
yeah,
yeah,
yeah.
Maybe in the end has got some.
Yeah.
Because he's so
Coming through.
Maybe
Hi there.
Oh, he was smiling all. Don't think that.
No.
Don't think that.
No, so tell you what though,